Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today for what we call an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. We handle misdemeanor cases, and certain cases of criminal misdemeanor cases. Criminal cases are divided into felonies and misdemeanors. Your felony cases are your more serious type of offenses, whereas your misdemeanor cases are commonly referred to as your petty offense. It doesn't mean that they're not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the charge. Felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have a capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life. Now, if a person, and a fine that does not exceed $10,000, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned earlier, you don't have to worry about that because your case is a misdemeanor case. Misdemeanors are divided into 3 categories. We'll start at the top and work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is fine only. That is, you can only be given a fine. You cannot be given jail time. The fine usually range from $0 to $500. However, now if a person they fail to pay the fine, or if the fine is converted to community service and they fail to perform the community service, then the court can issue what is called a capias pro fine. That means that there's a warrant for your arrest to either pay the fine or sit the time out in jail. And you will receive that $100 credit for every day that you spend in the county jail. Now, the next highest misdemeanor is a Class B misdemeanor, and the range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days in the county jail, or a fine that does not exceed $2,000, or you could be given both such fine and confinement. Then the highest misdemeanor is a Class A misdemeanor, and the range of punishment for a Class A misdemeanor is minimum 0 days to a maximum of 365 days in the county jail, which is a year, a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights. And the clipboard that you have in front of you, we're going to talk about your right to have an attorney. Now, there's a document on the clipboard that is titled Judge's Explanation of Rights to Defendants Without an Attorney. I'm going to go over that document with you. And it states that as a defendant in a criminal case, you have 3 options. Number 1, you may hire an attorney. And number 2, if you cannot afford to hire an attorney, you may request that an attorney be appointed to represent you. And number 3, you may represent yourself. Now, with number 3, you have to first waive your right to an attorney, that is, give up your right to an attorney, and you have a right to represent yourself. Now, if you want to hire your attorney, your own attorney, your case will be reset. Reset means that you'll be given another court date to give you time to hire your attorney. If you want an attorney, but you do not have enough money to hire an attorney, then you would have to fill out a financial questionnaire. The financial questionnaire is the document on the clipboard that is titled Waiver of Counsel for Purposes of Entering a, it's titled Affidavit, Jefferson County Affidavit of Indigence. And you would have to fill out the first page and then half of the second page, and then the bottom half of that page and the third page, the court will fill that out. You will fill that financial questionnaire out so that the court can determine whether or not to appoint an attorney to represent you. Now, if you want to waive your right to an attorney, that is, give up your right to have an attorney, if you waive your right to have an attorney, you will have an opportunity to talk to the prosecutor. The prosecutor is the assistant district attorney who's sitting in court at the table before you. You will have an opportunity to talk to him to see if you can work out a plea bargain. And what a plea bargain is just a settlement that you have reached with the state to settle your case. Now, you cannot talk to the prosecutor unless you first sign the waiver of counsel. Now, the waiver of counsel is the waiver of counsel for purposes of entering a guilty plea or proceeding to trial. And I'm going to go over that document with you in a few minutes. Now, you should be aware that there are dangers and disadvantages to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you decide to waive your right to an attorney, you may change your mind at any time and request that an attorney be appointed to represent you. Now, at the bottom of that document, you'll see 5 lines, and you'll see a statement in bold print that says defendant's choice. Mark initials next to only one choice. Now, if your choice is to hire your own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to request that an attorney be appointed to represent you, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney In this case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is to waive your right to an attorney or give up your right to have an attorney and you desire to represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, you will sign your name on the line that is titled defendant, and you will date it today's date, July 2nd of 2024. Now, for those of you who will be waiving your right to an attorney, that is giving up your right to an attorney, you'll have to read and sign the document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. And that document states that I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Now, when it says voluntarily, that means that no one is forcing you to sign this waiver. You're doing it of your own free will. And when it says intelligently made, it basically means that you know what you are doing. So you say, my waiver is voluntarily and intelligently made. Furthermore, I have been advised this 2nd day of July of 2024 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request that the court proceed with my case without an attorney being appointed to represent you. I hereby waive my right to counsel. Now, if that is your choice, then you will sign your name on a line that is titled defendant, and you will date it today's date, July 2nd of 2024. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. And what a trial by jury is, you'll have 6 people will be selected as jurors in your case. They'll sit in that area over there where those young ladies are sitting, and we call that the jury box. 6 citizens will be selected to serve as jurors in your case. They will listen to all the evidence, listen to all the arguments, they will deliberate, and then they will decide whether or not to find you not guilty or guilty. Now, you also have a right to waive, which means to give up your right to have an attorney. Now, if you waive or give up your right to not have an attorney, if you waive or give up your right to have a jury trial, you have a right to waive your right to have a jury trial. If you waive or give up your right to have a jury trial, then your case will come before the court in one of 3 ways. One way it can come before the court, that is, when I say the court, I'm talking about the judge. One way it can come before the judge is by way of a trial. And we call that a bench trial. It's a trial by judge only, but the judge will be the judge and the jury in the case. The judge will listen to all the evidence, listen to all the arguments, and then the judge will decide based on the law and the facts whether or not to find you not guilty or guilty. The other way that your case can come before the judge is by way of an unagreed plea bargain agreement. That is, you and the state have talked and you have not been able to reach an agreement to settle your case, and you want the judge to decide what your punishment will be. That's called an unagreed plea bargain agreement. And then the judge will decide what your punishment will be within the range of the punishment of the offense. Now, the other way that your case can come before the judge is by way of an agreed plea bargain agreement. That is, you and the state have talked and you have been able to reach an agreement to settle your case, and it comes before the judge, and the judge can do one of 2 things. The judge could either accept or reject your plea bargain agreement. Now, if the judge rejects your plea bargain agreement, you can simply withdraw or take your plea back. That is, for example, if you're in the state and worked out a plea bargain agreement, it comes before the judge says, well, I'm not going to accept that plea bargain agreement. Well, you say, well, judge, I withdraw my plea. And when I use the term plea, what I'm basically means is you can have one of three types of pleas. You can enter a plea of not guilty, which means you're telling the court you didn't commit the offense that you committed. You can enter a plea of guilty, which means that you're telling the court that you committed the offense that you've been charged with, or you can enter a plea of no contest, which means that you will not be contesting or you will not be fighting the charges. So if you enter a plea of guilty or no contest, it comes before the judge rejects the plea bargain agreement that you made with the state, you have a right to withdraw or take back your plea. Now, if the judge follows the plea bargain agreement or accepts the plea bargain agreement, and if you decide within 30 days that, you know what, you say, well, I think I've been wrongfully convicted or the court committed an error by convicting me, I'd like to appeal my case. Now, in order to appeal your case, you have to get permission from the judge that followed the plea bargain agreement. And if the judge gives you that permission, then your case will leave this court and it will go to the Ninth Court of Appeals, which is located right above us on the 3rd floor. And they will review your case. They can do one or two things. They can either grant or deny your appeal. If they grant your appeal, they can simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you can appeal your case to a higher court than the Ninth Court of Appeals. You can appeal your case to the highest criminal court in the state of Texas, which is called the Texas Court of Criminal Appeals, located in Austin, Texas. Now, you would have to file what is called a pro se petition for discretionary review. And I'll explain that. Pro se means you will be representing yourself. You will not have an attorney filing this petition. And you'll be petitioning the Court of Criminal Appeals to review your case, to see, one, whether or not your appeal should have been granted, or two, whether or not this court wrongfully convicted you or committed an error. And they can do one or two things. They can either grant or deny your pro se petition for discretionary review. If they grant your pro se petition for discretionary review, they can simply find you not guilty, or they can send the case back up to the Ninth Court of Appeals, or they can send it back down to this court and order this court to give you a whole new trial. Now, if they deny your pro se petition for discretionary review, then at that point, your conviction will stand. Now, as a defendant in a criminal case, you also have a right to have witnesses to come to court to testify. And what witnesses do, they'll sit in that chair with a microphone here. They can testify for you or against you. And if you're representing yourself, you can ask some questions. Or if you have an attorney representing you, your attorney can ask some questions. We call it either direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses to come to court. That simply means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because the state will be calling witnesses in the case. Now, you also have a Fifth Amendment right against self-incrimination. Now, I know we usually watch television, and you watch some of these law shows. They always talk about somebody saying, I'm taking a fifth. And that simply means that they have a right not to testify against themselves. They have a right not to incriminate themselves. That's the Fifth Amendment right against self-incrimination, the Fifth Amendment of the United States Constitution. Now, if you exercise your Fifth Amendment right against self-incrimination, that simply means that the state or the government or the district attorney's office cannot call you as a witness in your case, because you have a right, a Fifth Amendment right against self-incrimination. Now, you can waive or give up your Fifth Amendment right against self-incrimination, and that simply means that you will be testifying in your case. Now, you also have a right to have what we call discovery. And discovery basically means you have a right to see the evidence that the state has and will be using against you. And so that simply means you have a right to discover the evidence that the state has. Now, you have a right to see your statements, witness statements. You have a right to view audio recordings. Listen to audio recordings and view video recordings. You have a right to see photographs if they have them. You have a right to see lab reports, police reports. You also have a right to see whatever type of instruments that they may be using against you in your case. Now, you also have a right to waive or give up your right to have discovery. And by waiving or giving up your right to have discovery, that simply means that you will not be having access to the evidence that the state will be using against you because you waived or gave up your right to have discovery. Now, everyone that's here today for court, if you're here on a case or charge against you, that simply means that one, you have been arrested, and then two, you're out of jail on bond. You get out of jail on what we call a cash bond, which means that you paid the full amount of the bond to get out of jail, or you're out of jail on a surety bond, which means you paid a bondsman a percentage of the bond to get out of jail, or you're out of jail on what we call a PR or a personal recognizance bond, which means that you were released under your own personal recognizance with a promise to appear here in court. Now, every day that you spent in jail, that jail time can be used as credit towards your punishment. So, for example, let's say you spent 5 days in jail. And let's say you and the state have worked out a plea bargaining agreement, and the plea bargaining agreement require you to serve 5 days in jail. That's the agreement. What that means is you will not have to serve any more time in jail. Why? Because you will be given credit for the time that you've already spent in jail. We call that credit for time served. Now, if the state is offering you 7 days in jail, you spent 5 days in jail, that simply means you will only have to spend 2 days in jail because we'll take 5 from 7 and that leaves 2. Now, every day that you spent in jail can also be used as credit towards your fine and court costs. Now, you will receive $100 credit, or you have received $100 credit for every day that you spent in jail. And when I use the term day, I'm talking about different days. So for example, let's say you booked in jail at 11:58, let's say 11:59 p.m., 1 minute before 12 o'clock, right? And let's say you booked out of jail at 12:01, 2 minutes later. That's considered 2 different days, okay? And so every day that you spent in jail, you can receive credit toward your fine and court costs. And not only that, but every day that you spent in jail, you receive $100 credit toward your fine and court costs. So if you spent 5 days in jail, that's $500 credit that can go toward your fine and court costs. So if the state is offering you fine and court costs of $500, that simply means that you will not have to pay anything because the time that you spent in jail has already paid it off. Therefore, the fine and court costs will be taxed and retired. Now, if the state is offering fine and court costs of $700, you spent 5 days in jail, you have $500 credit. We'll take $500 from the $700, that leaves $200 that you will be required to pay on the day that you dispose of your case. Now, if you cannot pay it on the day that you dispose of your case, then we can do one or two things. We can put you on a payment plan, and if we put you on a payment plan, you can pay it off in monthly installments until the balance is paid off. Or if you cannot pay it off on a payment plan, then we can convert your fine and court costs to community service. And for every 1 hour that you work at a nonprofit organization in our area, you will receive $12.50 that will go toward your fine and court costs. So if you work an 8-hour day, that's $100. If you work 2 8-hour days, that's $200. So in the scenario that I gave to you earlier with it yielding that SpaceX says that you owe $200, if you work 2 8-hour days at a nonprofit organization, you would have paid off your fine and court costs. Okay, now Jefferson County has a program. When I say Jefferson County, I'm talking about the district attorney's office. Jefferson County District Attorney's Office has a program that is called pretrial diversion. And what pretrial diversion is, it's a program where they will dismiss your case and you can get it wiped off your record. And this is how it works. Okay, you have to get an attorney to help you to fill out the application and submit the application to the district attorney's office. It cannot be your first time getting in trouble. Well, it has to be your first time getting in trouble. You cannot have, let's say, a criminal history, a long criminal history. And then the third thing is, it cannot be for an offense involving resisting arrest, unlawfully carrying a weapon. Now, if you do qualify, the case will be dismissed. And once you finish the program, you can get it expunged from your record. Expunged means erased, deleted, or wiped off of your criminal history, like it never happened. Okay, so somebody pull your criminal history, they're gonna see a blank page because it's no longer there once you get it expunged from your record. Now, if you are a veteran of one of the branches, any one of the branches of the United States military, Jefferson County District Attorney's Office has a program that is called Veterans Court. It's for veterans only. The only criteria to get in the program is to be a veteran of any one of the branches of the United States military. And if you get into the program and complete the program, they will dismiss the case. Case will not appear on your record as a conviction, and you may qualify for what is called a non-disclosure. Now, what a non-disclosure is, unlike an expunction, a non-disclosure is there, but your record will be sealed to the general public, which means that they cannot have access to it. Now, when I talk about the general public, I'm talking about most of the public. Now, the government can have access to a non-disclosure. And there's a list of agencies, departments, and governmental agencies that can have access. But for the most part, the general public will not have access to it. Okay, so you can get a non-disclosure if you are in and complete the Veterans Court program. Now, this court has a program that is called the CSI program. CSI stands for Community Safety Initiative. It is a program that I started within taking office, within the first 100 days of taking office in March of 2017. And that program is designed to address the issue of what is called recidivism. Recidivism means that people commit crimes over and over. And so how do we address recidivism? Well, we address recidivism through the Community Safety Initiative. And in that program, we have partnerships with local agencies. One of the agencies that we have a partnership with is the Spindletop Center. Spindletop Center is our local mental health center for the Southeast Texas region. And what Spindletop will do, they can have private interviews either in our jury room at their facility, or maybe they can interview you over the phone, whatever is convenient for you. They have the capacity to do an assessment, and they also have the ability to develop a treatment plan for either outpatient or inpatient to fit your mental health needs. Now, in order to participate in the program, you do not have to be incompetent or insane. You can simply suffer from depression or anxiety or any other host of mental illnesses. And Spindletop has expertise to address your mental health needs. We also have a partnership with Spindletop that has a program that is called ATAR. ATAR stands for Addiction, Treatment, and Recovery. And we also have a partnership with our local Drug and Alcohol Council that has a program that is called OZAR. OZAR stands for Outreach, Screening, Assessment, and Referrals. Both programs are drug and alcohol recovery programs. They can address your drug or alcohol needs by conducting by having a screening. They can also do an assessment, and they can refer you for either outpatient, inpatient treatment, depending on what your drug and alcohol issues are. If you're unemployed, do not have a job, or you're looking for a better job, we have a partnership with our Golden Triangle Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. That's an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in any one of those areas, they will assist you in getting a job in the area that you're trained in. Now, if you have not graduated from high school and you have not received your GED, well, CICE also has a program where you can get your GED, your graduate equivalency diploma. Now, all of these programs that I just mentioned will not cost you anything. They're free. Only thing it would cost you, even though they're free, is just time. And in this code, I like to say we do not just give time, we take our time. That simply means that we don't just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people, we can make Jefferson County a safer place for all of us to live, work, go to school, raise our children, go to church, and raise our families. Now, I like to say that in County Court at Law number 2, we do not just have court as usual. We have unusual court, and it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we will make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. And so if you're interested in any one of these programs, just let us know. We have some brochures with the information on it, phone numbers that you can call and talk to people about getting into any one of these programs. Now, the other point that I need to make about the Community Safety Initiative, or CSI program, is that all of these programs that I just mentioned can be used as community service. So, for example, let's say you were required to pay a fine and court cost, but you can't afford to pay the fine and court costs because you do not have the income. And so the court converted the fine and court costs to community service. And for every 1 hour that you're in, say, job training program, or in the Spindletop program, or in the alcohol counseling recovery program, or the GED program, any one of the programs, 1 hour will go toward the program. $12.50 will go toward your fine and court costs, and then you get 1 hour of community service. So any one of these programs that you're in, every 1 hour that you spend in the program, you will be receiving credit toward your fine and court costs to pay off your fine and court costs. So I like to say that you're not killing 2 birds with 1 stone, you're killing 3 birds with 1 stone. You're in the program, you're getting community service, and you're paying your fine and court costs, all by doing one thing. Now, as I mentioned earlier, if you're interested in the program, we do have some brochures that we can give out to you. At this time, we have Deputy Hinton and Chris, who's going to come forward and tell you a little bit more about the program that Spindletop has to offer. Deputy Hinton, Chris.
Thank you, Your Honor. Morning. My name is Steve Hinton. I'm a mental health deputy by the state commission here at the sheriff's office. My coworker, Chloe. Chloe is a qualified mental health professional. The reason we are both here this morning in this courtroom is the judge cares about every single person who comes before the judge. Judge has found, and was proved, is those who have legal issues commonly have mental health needs, such as use disorders, or sometimes just a lack of community resources to help you in your particular situation.
A lot of mental health concerns such as anxiety and depression arise in the court setting. A lot of people deal with this and sometimes aren't able to address it. It's most common in the courtroom and we're here to help you if needed with anything like that.
So maybe this is your first time to be in court, maybe it's your 10th time to be in court. So in fact, what we're offering you today has the ability to change your life. We're gonna need something from you. We're gonna need you to share that need with us, and Chloe will explain exactly how you can do that very Friday.
So, when you guys first walked in, I handed everybody this form right here. What this form serves as is basically a baseline HIPAA consent form. Anything that you put on this form is gonna be private, and it's also protected by state law. Only I get to see it, so whatever you put on here, only me. A lot of the community resources are well-funded, but not known to the public. They're not advertising things like that, and there's a lot of loopholes. So, we're here to help if you need someone just to talk to or connecting to any community resources. Be sure to fill out this form right here.
Also have a flyer here that I want to give everyone before you leave here today. On the back, it tells you some of the advantages of actually participating. But on the front, it has a 1-800. If you ever have a reason to call that number, you can get help immediately. So just shortly, the court is going to go into recess. When it does, we'll come out there, we'll visit with you, we'll pick up those documents from you. I will answer any questions you may have at that time as well, and we'll also hear them out at that time. Thank you very much. Thank you, Your Honor.
Thank you, Deputy Hinton and Cloyd. Okay, ladies and gentlemen, we're going to go into recess in a few minutes. But before we go into recess, I need to inform you that the paperwork that you have on the clipboard, we're going to pick that paperwork up and then we're going to go over that paperwork. And once we finish going over the paperwork, we will ask that you will come up before the bench or before the judge so that we can go over the paperwork. Now, this is going to take us a little time to do. Also, the folks from Spindletop is also going to come out to you and maybe talk to you. Now, if anyone need any help with the paperwork, we have our court personnel who's here, who is ready to help you with the paperwork. You just simply raise your hand, let us know that you need help, and then we'll help you with the paperwork. Now, if you need to use the restroom, there are 2 restrooms right outside of the courtroom in the hall. The men's restroom is next door in front of County Court at Law number 3. And the women's restroom is on the opposite side of the hall in front of the 172nd District Court. You'll be allowed to use the restroom and then you can come back in the courtroom. Please do not leave the courthouse. If you leave the courthouse and if your name is called, you're not here, a warrant can be issued, your bond can be forfeited, and a warrant can be issued for your arrest. So at this time, again, ladies and gentlemen, we're getting ready to go into recess. And again, if you need any help, just please raise your hand and our court personnel will assist you with your paperwork. Court is in recess. Jefferson County Court at Law number 2 is in session. The court is in session in 2 cases, cause numbers 24-CCCR 0974, cause number 24-CCCR 1171. Both cases are styled the state of Texas versus Patrick M. Griffin. Patrick M. Griffin is currently being prepared to come out. And Mr. Griffin is represented in this case by his attorney, Laura Perazzo. Ms. Perazzo, how are you doing?
Doing well, Your Honor, thank you.
Okay. And the state is represented in this case by attorney Andrew Hubel. Attorney Hubel, how are you doing?
Doing well, Judge, and yourself.
I'm doing fine. Now, Ms. Perazzo, the court is going to conduct a hearing, or actually a trial pursuant to Article 46B 054 and 46B.051 of the Texas Code of Criminal Procedure. And pursuant to Article 1.24 of the Texas Code of Criminal Procedure, the right to public trial, or all trials and proceedings shall be public. However, pursuant to the case of Lilly versus State 365 Southwest 3rd 321, the right to public trial is not absolute and may be outweighed by other competing interests, such as the interest in security, to prevent the disclosure of non-public information and ensure that the defendant receives a fair trial. Ms. Perazzo, are you requesting that this hearing be closed to the public to prevent the disclosure of non-public information?
Yes, Your Honor.
The court finds that the party has advanced an interest that is likely to be prejudiced to her client in that it would disclose non-public information. The court finds that the request is no broader than necessary to protect the interests of her client. The court has also considered other reasonable alternatives to closing the hearing, and the court makes these findings are adequate for the closure of this hearing. So at this time, this hearing will be closed to the public.